In this lecture, we would understand why and how judiciary is one of the very important constituents of the three pillars. Before beginning, let's understand what are the three pillars. The first is executive, the second is legislature, and the third is judiciary. What's the difference? Judiciary settles any dispute which arises. Legislature is the law-making body, and executive is the administrative body which executes the law being created by the legislature. So, to understand it in very simple terms, we have Parliament. It comprises of Lok Sabha and Rajya Sabha. Both of these together are called as the legislature. So the members of the parliament, members of legislative assemblies are all part of legislatures at the center and the state level. But from this whole legislature, we have a council of ministers. Now these are the group, the cabinet ministers who work very closely with the prime minister. So prime minister, the cabinet and president, these form the executive within the parliament, and then of course you have the administrative officers who actually execute those on the regional and the ground level. So that is where the law which is created in the parliament is being executed by a group, and this is executive. But judiciary is considered as an independent pillar. Why so special? The major thing is the appointments of the judiciary are taken care by the executive. However, in case there is removal of any judge, that is being taken care by the legislature. So there is a very fine balance of the judiciary with executive and legislature, and the salaries and the incentives of the judges is not determined by the legislature or the executive. It is independently determined. It's not determined by the legislature or the executive, and therefore it is considered as an independent pillar. So here we begin with why there is a need for an independent judiciary. We understood why India has an independent judiciary system, but what is the need? Why it is not dependent on executive or legislature? The reasons are very, very simple. The reasons are judges should be able to perform their duties without any fear. They should not be under any political pressure, any other executive pressure. So they should be able to perform their duties without fear and also without favor, without favoring any one organization or the other, or one political party or executive or the legislature or whatsoever. So in order that the judges perform their duties without fear or favor, settle the disputes properly, and make sure whatever laws are given in the Constitution of India are applied equally to all. When I say equally to all, what does it mean? It means that be it a rich person, a poor person, across genders, male or female, forward class, backward class, across all dimensions, these laws stand uniform. They should be applied, and they are applied equally to all of them. And that is what judiciary looks into. It also ensures that our system runs on a democratic line. If there is no independent judiciary, what would happen? A chance can be there that dictatorship drives in. To make sure there is no element of dictatorship running into, it's very, very important that an independent pillar, which is judiciary, needs to be reinforced and strengthened and needs to be independently established. Also, judiciary is accountable to the Constitution, to all the democratic traditions of the country, and no other organization should interfere with the functioning of the judiciary. Therefore, we say there is a need for judiciary which is independent. Now, another big question. We have an independent judiciary, but how do we protect it? There can be cases where the judiciary is not protected. That means the judges are not protected. So, in that case, there is no point putting the judiciary as an independent body. So, how do we ensure that the judiciary is protected? The process of appointment of the judges is relatively simple, but In case there has to be a removal of judge, the process is very stringent, very difficult, and it runs through a complete legislative process. It can only happen when there is a misconduct which is proved on behalf of the judges, and in only that case the judge can be removed. And why it is so? This enhances or gives more power to the judges and ensures that there is good security for the judges. This would ensure that our independence of the judiciary is protected. So legislature are not involved in the appointment. In the appointment, executive is involved. In the process of removal, legislature is involved. The judge who is to be appointed must be an expert in the field of law, must be a lawyer by profession, and should not be easily diverted by any political opinion, any political ideologies. Also, judges work independently in terms of finances, independent from the executive and the legislature. Protection of judge from any unfair criticism is also important. So all these factors ensure that judiciary remains independent and the judiciary is protected. Now we have been for long saying that appointment is done through executive, removal is done through legislature. Let's dive in and understand how this actually happens. So the process of appointment. Chief Justice of the Supreme Court. Who is Chief Justice of the Supreme Court? So, if we understand the structure of our judicial system, it is Supreme Court as the main body. In all the states, there is High Court. Some of the states have combined High Court. Then there is a District Court, and there can be lower courts or local courts which can be handled at basically the lower matters can be resolved. Now, the Supreme Court, which is the highest judicial authority in India, has the Chief Justice and the judges. So, the Chief Justice, who is the Chief Justice? Chief Justice is the senior most judge of the Supreme Court, and that senior most judge is appointed in consultation with the President of India, and therefore whose role is important? The role of executive comes into play here. Now, as far as the appointment of the Chief Justice is concerned, the senior most judge is appointed. However, there have been two major exceptions which we would cite here. One is the exception which occurred in 1973, where A.N. Ray was appointed the Chief Justice of India and he superseded three senior judges. There was another case in 1975 where M.H. Beg was appointed and he superseded Justice Khanna. So there were two major instances which we can cite where the senior most judges were not made the Chief Justice of India. One was in 1973 where A.N. Ray was appointed. Above him there were three senior most judges. In 1975, M.H. Beg was appointed superseding Justice Khanna. Also, judges of the Supreme Court and the High Court are brought by President's consultation with the Council of Ministers. So again, whose role is important? The role of executive, not the role of legislature. Now, Chief Justice recommends the name of the person who are appointed in consultation with four senior most judges. Now, that is again the part of what system? We call this as a collegium system. This collegium system in judiciary is a unique system which makes recommendations for the appointment of the judges. At the moment, the matter of the appointment of the decision is decided by the group of senior judges of the Supreme Court, and that carries much more greater weightage, and this is done for both the Supreme Court as well as the High Court. Now, how is a judge removed? As we said, removal of judge is not very easy. They can be removed only in the grounds of misbehavior or incapacity to prove, and the charges must be approved by a special majority. Types of majority: special majority, normal majority we have understood, ordinary majority we have understood in our previous lecture separately, so just go through that for understanding the types of majority. But the charges must be approved only by a special majority in both the houses of the parliament. Now let's understand one interesting case. In 1991 there was the first ever motion to remove a Supreme Court Justice, and that was signed by 108 members of the Parliament. Justice Ramaswamy, who during his tenure as the Chief Justice of Punjab High Court, was accused of misappropriating certain funds. Now it was believed that 1 year later, in 1992, the proceedings started in the Parliament. He was accused of using the public funds for his personal purpose and also disregarding the statutory rules. Now, in this case, what happened? The parliamentary motion was brought for the removal of the judge, but the removal got 2/3 of the majority in both the houses by the members present and voting. So 2/3 majority was there. But what was the problem? The problem was Congress party abstained from voting. The members of the Congress party said that they are not ready to vote. In that case, the motion was not even supported by half of the total strength. So not even the 50% of the total strength was there. Since 50% of the total strength was not there, what happened? The consequence was that this motion could not be successful. So, as we said, there has to be a special majority in both the houses. So, despite the fact that 2/3 of the member present and voting said that Justice Ramaswamy should be removed, justice was not removed because only less than 50% of the strength of both the houses was present at the time of voting, because Congress party abstained from voting. So, we understand that the cases of removal are very, very difficult. The next is understanding the structure. Now, Supreme Court, as we know, it is the highest court, can transfer judges of the High Court. It can move cases from any court to itself, which is the Supreme Court, and also transfer case from one High Court to another High Court. At the High Court, the power to hear the appeals from the lower court to check whether the fundamental rights are working or not, they are violated or not, is being ensured through various writs which can be brought in High Court. Dealing with any case which is in the jurisdiction of the state, exercising the control over the lower courts. Then we have the district courts and the subordinate. Subordinate courts are the lowermost courts where you have the civil and the criminal offences which are dealt. District court works at a district level. It checks the decisions of the lower court and also sees if there are any significant criminal offences or criminal cases which are there. In India, the structure of judicial system is very, very integrative, because Supreme Court has a stand and works in a pyramidal fashion where all the courts below the Supreme Courts are under the eye of Supreme Court, and the functions of the lower court are directly monitored by the relatively higher courts. So what are the powers? When it comes to Supreme Court, the scope of the power is very wide. We say there are 4 types of jurisdictions that can be handled by Supreme Court. These are original, appellate, advisory and writs. So, what are those? We will understand those one by one. The first one that we would understand is the original jurisdiction. Original jurisdiction means that Supreme Court, the cases can be taken directly to the Supreme Court. It's not that I had a fight with my neighbor and I take the case directly to the Supreme Court. Definitely not. So, original cases are those cases which are entertained directly by the Supreme Court without the interference or without going to the lower order courts. What could be the scenario in which this can happen? This can happen when there is a dispute between center and state. So if there is a dispute between center and state, if center is involved, which is the court which would look towards the center, so definitely Supreme Court. So that is the original jurisdiction. settling disputes, interpreting the powers between the center and the state, taken care by the Supreme Court under the original jurisdiction. So the first jurisdiction which we understood. The second type of jurisdiction is writs. That means if a person feels that the fundamental rights of any individual are violated, these person can consider moving directly to Supreme Court. So if there is an individual who feels that the fundamental rights are violated either at the state level or at any other level, then this can go directly, the person can go directly to the Supreme Court. Supreme Court can give special orders to the High Court and the lower courts to work accordingly. Now, how would this happen? This would happen through the issuance of writs. The 5 types of writs which we have understood in a separate lecture, those are prohibition, quo warranto, certiorari, habeas corpus and mandamus. So these are the 5 writs which are issued, which we have understood in a separate lecture. So in any case, if fundamental rights are violated, the person can approach the Supreme Court directly for any remedy that can be issued. The next is appellate. Appellate jurisdiction, as the name suggests, is the appeal. Now, what happens? Let's say the decision is already given by the High Court, but for some reason I am not happy with the decision. I feel that the decision is not in the right way it should be. So what I do is I move from the High Court to the Supreme Court and appeal the Supreme Court to look into it. But when can I do that? I can do that only when High Court considers that this case is fit for appeal and this is a serious matter of interpretation of law which is required. In that case, High Court would permit me to go to Supreme Court to appeal. But there can be case where High Court does not allow me to appeal to the Supreme Court. But still, I can admit to the Supreme Court and ask that whether this is a matter which I can appeal in the Supreme Court or not. Okay, so the first chance is given to the High Court. If the High Court permits, then definitely Supreme Court would handle it. So it is a matter of appeal which goes to the Supreme Court. In case High Court says no, it is not required, and still I appeal to the Supreme Court, Supreme Court can consider my appeal. It can oversee the decision of the High Court that this is required and would be handled in the Supreme Court. Clear? So that is what is appellate jurisdiction. Now, appellate jurisdiction applies not only to Supreme Court, it also applies to High Court in the case the cases are being taken by the lower court. So High Court can do whatever falls below it. It cannot take a case of Supreme Court and handle it. But yes, any case which is in the subordinate court, district court, any court lower than the High Court would be taken as an appeal in the High Court. So this appellate jurisdiction power holds with both Supreme Court as well as High Court. The next is the advisory power. Now here, President in certain matters of public interest can ask for an interpretation of the Constitution to the Supreme Court. And this is what? President is seeking an advice. Now, there are 2 things which can be there. The first is Supreme Court is not bound to give the advice. Supreme Court, if it feels that the advice is to be given, it would give. If Supreme Court feels that no requirement for the advice, it can remain quiet. President. Supreme Court can give the advice, but President is not bound to accept the advice. If President feels that I should accept, the President would accept. If the President feels I don't want to accept, President cannot accept. Now you might wonder, what is the use of such a power if Supreme Court is not bound to give it and President is not bound to accept it? Then why there is this power? What is the use of this power? The use is pretty simple. The use is President can get legal opinion. President can understand the legal matters and get the legal opinion. So that's one very important thing. And the second important thing is any unnecessary legislature which is required or any unnecessary litigation which is required can be avoided. So unnecessary litigations can be avoided, unnecessary obstructions within the lawmaking can be avoided, and legal opinion can be sought. So these are two major advantages why advisory jurisdiction is important. There are two important articles. One is Article 137, one is Article 144. Let's understand the interpretation of these two articles before we proceed. Article 137 says Supreme Court has the power to review any judgment made by it. Okay, so any order, any judgment made by it can be reviewed within the Supreme Court. So the power to review. Article 144 of the Constitution says that all authorities, be it the civil authorities, be it the judicial authorities, shall act in aid, in alliance with the Supreme Court. So these are the two powers, the two articles of the Constitution which mention the powers of the Supreme Court, and this also talks about a unified nature of our judiciary and the powers of the Supreme Court, because the decisions which are taken by the Supreme Court are also binding not only to the Supreme Court but all other courts lower than the Supreme Court within the territory of India, and must be accepted by all the courts within the territory of India. The next is few related terms. One is judicial activism, the other is judicial review. We'll understand these one by one. What is judicial activism? There is public interest litigation or social action litigation, two important terms that you commonly hear. Now, let's say I am an individual of the country, I am being aggrieved by certain issue. So what I do is I approach the court. Now when I approach the court resolves my issue. But there can be certain circumstances where the person is poor, person is disadvantaged, person does not have adequate resources to move to the court directly. In that case, someone else on behalf of that person takes the case to the court. Now, this could be taking the cases for the rights of the disadvantaged people, the rights of the poor people, any number of cases which pertain to backward community or tribal groups or vulnerable group or a vulnerable section of the population. So in that case, what happens is the person is not able to take the issue directly to the court. So on behalf of that person, there are certain social organizations, there are non-governmental organizations, there are other people who take this to the court, and this is through the public interest litigation. Now, how public interest? This can be the right for their territory. Let's say there is a dam project which is coming, which requires rehabilitation of the people in the region around. Now, if the people are not literate, they cannot go to the court on behalf of them. Any non-governmental organization can reach the court to understand that and therefore file a PIL, a public interest litigation, that their lands, their region would go, what would be their source of survival, where they would live, their houses would be destroyed. So similar PIL was filed in the case of Sardar Sarovar Dam, when the height of the Sardar Sarovar Dam was aimed to be increased. So there are numerous certain examples where we say PIL or litigations can be filed. When there is an issue of clean air, unpolluted water supply, decent standards of living, definitely there is an interest litigation that comes in. Also, we need to understand that these have been highly successful. Let me quote one example from 1984. In 1984, there was a case of Bandhua Mukti Morcha. So, Bandhua Mukti Morcha, as the name suggests, was the case where Mukti Morcha, that is to liberate whom? Bandhua, that means the bonded labor. So Bandhua Mukti Morcha was a case to liberate the bonded laborers or to give them their rights. So there was a case which was Bandhua Mukti Morcha versus Union of India. Now in this case, what happened was the abolition of the Bonded Laborers Act was passed. That means under Article 21, bonded laborers must be identified and must be rehabilitated properly, and this was later ensured to bring in that under Article 21 of the Constitution, we say there is dignity, human dignity is maintained, and this human dignity is nothing but focusing on the concept of rehabilitation of the bonded laborers in India. So In case the people fail to do so, it would be the violation of Article 21 of the Constitution. Now, also the people who are contesting the elections need to make sure that the system runs on a clean basis. So how it is ensured? When the person says that, okay, I want to contest the election from my constituency, the person would have to file an affidavit. That affidavit would bring in or disclose the income of an individual, the assets that an individual hold, the educational qualification, the criminal history, and all other related things to that candidate would be disclosed. And why it is done? This ensures that the electoral system in India is free and fair. So to make sure that the electoral system runs on a free and fair basis, this is a declaration which is required. But we have seen so much positive sides of this judicial activism, but it does come with a negative side. What is the negative side? Sometimes the courts are overburdened because there are so many public interest litigations which are filed for the rights of so and so and so and so and so people. Now, this is one of the drawbacks, and therefore we have huge pendency of cases in the courts. Also, this creates a blurred distinction between executive legislature, executive judiciary, and therefore creates a kind of narrow boundaries between the identification of the different streams or the different pillars. Now, let me take one simple example. If we want to reduce air pollution or any other levels of pollution, there are investigations which are done. Now, these matters are handled by the administration. So executive plays a role, but it is under the supervision of whom? It is under the supervision of the legislature, and then there can be a PIL. So again, judiciary comes in. So there has to be a very fine, delicate balance between the three organs or the three pillars. So that was judicial activism. The next is the rights of an individual. Judiciary, what's the role? The judiciary has the role to protect the right of an individual, so to protect the fundamental right. As we said, in the case the fundamental rights are violated, writs are issued. So, judiciary is the protector of the fundamental right. It is the interpreter of the constitution, and it does has a power for judicial review. However, this term judicial review is not nowhere mentioned in the constitution per se, but the court has the power for judicial review. What does that mean? Judiciary can interpret the constitution and the laws which are being drafted by the legislature. So laws which are being created by the legislature can be checked by the judiciary. The constitution can be interpreted by the judiciary. We'll understand very interesting cases of those in a while. Also, in case there is a kind of protection of rights for an individual, we take that into account very, very carefully. So, protection of rights by the issuance of writs, as we said, to ensure that fundamental rights are not violated, can be handled at the Supreme Court as well as the High Court. In the case of Supreme Court, it is under Article 32, which is called as the heart and soul of the Constitution. However, for High Courts, it is Article 226. So the same article, the same concept, the same writs apply for High Court as well as Supreme Court. Under High Court, it's Article 226. Under Supreme Court, it is Article 32, which is called as the heart and soul of the Constitution. We have covered a separate lecture on Article 32. Very, very important for you to go through. Then also, Supreme Court can declare law as unconstitutional and non-operational. This comes under Article 13. Under Article 13, Supreme Court has the right to declare the law as unconstitutional and non-operational. Now, review of judicial processes we have already understood, and we have seen why review is so important. We do have certain cases where we understand that there have been cases where violations have been done, and in those cases review should be further strengthened. So the case of Keshav Nandan Bharti is a very good example which we would understand in a while. Not only in India, in South Africa if we talk, the fundamental rights of the citizen is brought in the ambits of the constitutional code, and the cases of violations of other persons are taken into account. Now, when it comes to the parliament, what are the things which are taken into account? There is the role of executive which comes into play. Now, judiciary gives the directions to the executive. For example, CBI is given the directions to investigate certain matters which can be against certain politicians, certain bureaucrats. We have already gone through cases like Hawala Kand. We have the Narsimha Rao case, the illegal allotment of petrol pump case. In all those cases, CBI set an inquiry. Now, this inquiry was against politicians, was against the bureaucrats, and therefore separation of powers and the checks and balances are maintained. So judiciary plays an important role here. Also, judiciary helps understand what is the scope of right to property, right to amend the constitution, the right to abridge the fundamental rights, and so on and so forth. So a clear-cut distinction of the powers has to be made. And finally, we understand what are the key takeaways. So during 1967 to 73, there were various reforms. For example, land reforms, the preventive detention law, the law for reservations of jobs, the law for acquiring private property for public purposes. All those were discussed. And there were conflicts which arose between the legislature and the judiciary during this time. In 1973, there was a breakthrough case, the case that we mentioned prior, and that was Keshav Nandan Bharati case. Must to remember if you are a student of political science. Keshav Nandan Bharati case, in this case, the court ruled that the basic structure of the constitution, nobody, even the parliament, can violate. So even the parliament does not have the right to violate the basic structure of the constitution, and the basic structure cannot be changed. Now, the thing that came up here was first that the right to property was not part of the basic structure was given, and the second was the court reserved its rights to decide whether the various matters are part of the basic structure of the constitution or not. So two things which came as part of the Keshav Nandan Bharati case. I repeat again, very very important, this case made it sure that the court under this case said that the basic structure of the constitution cannot be violated. Even parliament does not have the right to violate the basic structure of the constitution. Two major things which were brought, that right to property was not the part of the basic structure of the constitution, and secondly, the courts reserved its rights, courts reserved itself the rights to decide whether these matters are part of the basic structure of the constitution or not. Also, in 1979, the right to property was taken away. So, Constitution provides for the conduct of judges cannot be discussed in the parliament. Judiciary too has to be criticized if any cases must be taken into account at a specific level, and legislature if seen violating should be brought under the judicial ambit as well. So even the parliament does not have the right to violate the fundamental structure of the constitution. So this was about the importance of judiciary, why in India we have an independent judiciary, the powers of the Supreme Court which are under four heads, original, writ, appellate and advisory powers, and then understanding the appointment of the judges, the removal of the judges, the concept of judicial activism, issuance of public interest litigation, social action litigation, and judicial review, which is not technically mentioned in the constitution but yes is an important element of the judicial issues. So that was something that we discussed in this lecture. We would be covering many interesting lectures in political science, covering your NCERTs 11th and 12th. Stay tuned. Wish you very good luck for your preparation. For more details and lecture handouts, refer the links below.